Welcome to the Rozanne On Demand CFPB video series, featuring Ontario System's Chief Compliance Officer, Rozanne Anderson. Widely recognized as a leading authority on collection-related compliance, Rozanne leads Ontario System's corporate efforts in response to the CFPB's launch of compliance examinations in the arm industry. In this ongoing video series, Rozanne takes a deeper dive into the entire regulation, helping you make sense of the new rule and what it means for your agency. Before we get started, please take a moment to review our legal disclaimer. The information shared today is not legal advice. Please consult with your own independent legal counsel before making any business decisions regarding the use of this information.
Welcome to today's video podcast episode. Today we will be focusing on the presumption of compliance with the call attempt and call conversation restrictions, as well as the presumption of non-compliance with those restrictions. As many of you know, the CFPB has presented us with call attempt restrictions and call conversation restrictions in response to the industry's plea for guidance with regard to call frequency. The CFPB, in its notice of proposed rulemaking, actually did not qualify its decision that any attempt to communicate or any conversation within a certain period of time clearly would be a defensible position for the debt collector. Meaning, if you complied with the restriction, they didn't care what kind of communication it was. It could be a text, it could be an email, it could be a call. If it was limited to a certain number per week and the conversations were limited to a certain number per week, boom, the debt collector was in the clear. You had a pure, clean defense to a claim that you were calling with the intent to harass, oppress, or abuse the consumer. Well, that clean protection fell away in the final rule for debt collection. What do I mean by that? Instead of simply saying a debt collector may do something a certain number of times, they said if the debt collector complies with the call attempt restriction or the call conversation restriction per week, there will be a presumption that the debt collector did not harass, oppress, or abuse the consumer. A presumption simply means that absent any other evidence to the contrary, if you were in court, the judge would say, I see no reason not to rule in favor of the debt collector. They complied with the restrictions, as far as I can tell, no evidence says to the contrary, boom. You win. The problem is that if there is evidence introduced in the at trial that is offered by the plaintiff, for example, the consumer or the person, I should say, who you communicated with, to suggest that you did intend, the debt collector did intend to harass, oppress, or abuse the consumer, then the judge will say, well, I think the presumption of compliance, Mr. Debt Collector, falls apart because the plaintiff has offered some credible evidence that your intent was, in fact, to harass, abuse, or oppress the consumer. So let's take a look at the examples the CFPB has provided us to understand evidence that a person could bring in a trial to establish or at least attack the presumption of your compliance with the call attempt and call conversation restrictions. The first one is if the frequency and the pattern of those 7 call attempts is so egregious on its face that the judge would have to rule, I know you did limit this to 7 call attempts in a week, but as far as I can tell, you bombarded the person who you were attempting to communicate with those 7 attempts, one right after another. In addition, while you were doing that, you decided to add some text communications to the mix. I rule in favor of the consumer because they have brought evidence that attacks or means that the presumption of compliance that otherwise would have existed had you spaced those attempts to communicate or those attempts to call out, now I rule in favor of the consumer. Let's look at another example having to do with the frequency and pattern of the voicemails and the intervals in between. The same logic will apply here as it did with the call frequency pattern. If the voicemails are of such a frequency and at intervals that any reasonable person would believe, clearly this debt collector is showing evidence that they are intending to harass the consumer, then the presumption of compliance with the call attempt restriction falls apart. So even though you may have only left 7 voicemails in a 7-day period with that person per debt, if the end result is that, for heaven's sakes, this person has received, you just loaded up their voicemail in an hour with all the voicemail messages. Similarly, the judge has the right to step back and say, I know this indicates that I know the law states that a debt collector may attempt to communicate with a person by calling them, attempting to call them or placing a call no more than 7 times in a 7-day period. But if you're collecting 7 debts and you decided to attempt to call them on all 7 debts in one day, such that the consumer actually received 7 times 7 or 49 attempts to call in a single day, the judge might step back and say, this is not carrying out the spirit of this law. And I would say, in the judge's opinion, that this constitutes evidence of the debt collector's intent to harass that consumer. The long and short of this is to understand that even if you stay within the restrictions of 7 calls to a person per debt in the 7-day period, you could still lose the case if the claim is harassment, depending upon some of the factors I've shared today. Also, the CFPB went on to explain that a consumer could say, yes, this debt collector did limit the call attempts to 7 per week, but the content of the voicemails were so egregious that they nonetheless show evidence that the debt collector intended to harass or abuse the consumer. So this does not mean that any 7 call attempts in a week are permissible if the content of, let's say, the voicemail messages is egregious on its face. Another example of a piece of evidence the consumer could bring in an action claiming that you harassed or abused or oppressed the individual is if they can show that they had already forbidden you from calling them about that debt. So if any person underscore person, whom you attempt to communicate with about a particular debt has already told you, I do not want to talk to you about this debt, then you are going to have a problem because the presumption of compliance with this call frequency restriction and call attempt restriction could be attacked in court because of the restriction the consumer or the person placed on your ability to call them about that debt. So those are several examples of pieces of evidence a person could bring in court to attack or destroy the presumption of compliance you would otherwise enjoy based on the Regulation F's call attempt and call conversation restrictions. Fortunately, the CFPB has not left all of the cards in the hands of the called party. The CFPB has taken great efforts to explain that there are certain situations and certain defenses a debt collector may raise if they are sued under this section of Regulation F for harassing the consumer, oppressing them, or abusing them with regard to their call attempts or their call conversation frequencies. Examples of these defenses that a debt collector may raise to defend their position and to explain why the number of call attempts may have exceeded 7 per debt to that person per 7-day period would be if because the debt collector was under an obligation by law to contact that consumer, and it's a coincidence that they had to hit 8 call attempts in a week or 2 conversations in the 7-day period. For example, there are some mortgage servicer requirements that absolutely require at a certain time that the mortgage servicer, debt collector, if you will, contact the person about an event happening with regard to their mortgage. Let's just leave it at that. That's an example of another law, a parallel law, that requires the debt collector to place a call to the consumer and have a conversation with them, that if it causes them to trip the wire, so to speak, and exceed the 7 call attempts in a week or the 1 conversation per week, the CFPB is saying this is a reasonable explanation, and you should not lose the protection of the presumption of compliance because of it. Another example is if the court actually orders the debt collector to engage in a certain telephone conversation with the consumer. If you're under a court order and that's why you exceed the 7 and 7 restriction, then the CFPB is recognizing that that is a defense to a claim that you actually exceeded it and it was done to harass the consumer. The CFPB is saying, no, you can protect and preserve the presumption of your compliance with the requirements if, for example, it was due to a court order. Another example, which I found to be rather generous on the part of the CFPB, is let's just say the debt collector attorney is actively engaged in settlement negotiations of the collection litigation with a person. In this case, it would probably be a consumer. Let's say they're in active settlement negotiations, and if you know anything about debt, about collection litigation law and litigation, the settlements will go back and forth. All right, we'll settle it for $5,000. We'll pay $2,000. All right, we'll go down to $4,000. Okay, we'll go up to $2,500. The back and forth of a settlement negotiation can trip or cause you to exceed the 7 call attempts per week or the 1 conversation per week restriction. CFPB recognizes that as a perfectly explainable reason why you exceeded the restrictions, and one that should support your ability to preserve and protect the presumption of your compliance with the call and call conversation restrictions. Another example is if the consumer actually asked you to call them back and provide them with more information about the debt. Now, one may say, isn't that the same as consent? Well, I think it is, but the CFPB has gone on to explain that if there's really a bona fide reason, such as not just please call me back tomorrow, and you have the 7 days to do so per the consumer's consent. But in this case, it's really literally focusing on the content and the reason the consumer needs you to call them back. If that's the reason for the call back that causes you to exceed the conversations per week restriction, then the CFPB says this should be recognized as as evidence that should not destroy your ability to be protected by the presumption of compliance. Finally, they talk about a situation where right in the middle of a conversation where you're actively either offering a settlement or they're negotiating payment or setting up a payment arrangement and the call drops for no explainable reason. It's not like they hang up or you hang up. The call literally drops mid-sentence, as we all know how that can happen. The CFPB says this is a great example of what the debt collector can raise as a defense if the consumer later claims, well, we had more than 1 conversation per week. Well, if that's the reason, the court says, well, that's kind of a reasonable explanation, and we are not going to destroy the debt collector's presumption of compliance with the restriction for that reason. So those are a number of examples of how the CFPB has armed consumers with abilities to challenge this presumption of the debt collector's compliance with these call attempt and call conversation restrictions, as well as examples of evidence debt collectors may bring to explain why they may have exceeded the call attempt or the call conversations in any particular 7-day period. I hope that helps explain some of the defenses and some of the attacks that can be made on the call attempt and call conversation restrictions as presented in section 1006.14 of Regulation F. Thank you for joining us today.
Thanks again for tuning into this week's episode of the Rozanne On Demand CFPB video series. As always, be sure to visit the Ontario Systems website for more exclusive events and information regarding the 2021 CFPB new rules.